Hello friends, welcome back to VOW DAYS. Welcome to the discussion of the Prelims test series of Vision IAS. This is part 4 where we are going to finish the first test, and we will be discussing from question number 76 to question number 100. And before we begin, a small information. So this is our Telegram channel, what you can see on your screen. So do join our Telegram channel to get more information with regarding to the courses that we provide, with regarding to the free content and everything, and all the videos as well. Okay, and you all know we are providing summaries for the prelims test series, for the mains test series of Vision, and even the summary of the monthly magazine as well. You can check the details from our Telegram channel. And the document that we are using for the discussion is the summary document that we have prepared. So this is a 10-page document of the Vision prelims test series. That is the first test, in fact. Okay, so for every test we will be preparing summaries, and you can use these summaries to enhance your revision, to increase your revision speed and all. Okay. Now let's begin with the 76th question. The 76th question is directly on the Controller and Auditor General. So this CAG, Controller and Auditor General, is a constitutional body. So which article talks about the CAG? It is Article 148. The 148 talks about the Controller and Auditor General. He is the head of Indian Audit and Accounts Department. The term of this CAG is 6 years or 69 years. This is the 65 years, not 69, 6 or 65 years, this is the term. And the CAG, if you see, no minister can represent him in the parliament, and also no minister can be called upon to take any responsibility for the things done by CAG. So these are the basic information about CAG you might have known. Next question, 77th question is on Sarkaria Commission, directly on Sarkaria Commission. The Sarkaria Commission, if you see, this is a commission on the center-state relations appointed in 1988. This commission is on center-state relations, and this commission, if you see, it has given various recommendations for the betterment of center-state relations along with Punche Commission. Okay, and another thing is, if you see, we have the SR Bommai case in 1994. Under this SR Bommai case, Supreme Court gave various recommendations regarding the usage of Article 356, because Article 356, if you see, this Article 356 is the most misused article, because this deals with the president's rule in the states. It deals with president rule in the states, and when the government at the center changes, this Article 356 was used, and the governor rule was imposed in various states after the independence. So in order to prevent its misuse, the Supreme Court and Sarkaria Commission has given various recommendations regarding its usage. So we will see what are the situations under which, or what are the situations wherein which we have to implement this, or we have to, or the government has to implement this Article 356. So the situations are, first is hung assembly. So what is hung assembly? Generally, for a party to come into power, it should have more than 50% of seats. That means, let's say if a state has 100 MLAs, for a party to form government, it should have support of minimum of more than 50 MLAs. That is, 51 MLAs have to be there with them. Only then they can form the government. Though, so okay, so this is one thing. So if there is no clear majority, then this issue will be there. And so there is no clear majority means, that means it's a hung assembly. And during that time, if there is no coalition that is being formed, even then this Article 356 can be imposed. And also, when the ministry, that is the Council of Ministers, resigns after defeat in assembly, and no party is able to form ministry, that means maybe because of no confidence motion, or maybe because of any other reason, if the Council of Ministry resigns, and after the Council of Ministry resigns, no party, if it claims for any for the formation of government, then also Article 356 can be imposed. And also another important reason, or another important time when this Article 356 will be imposed is when there is when the state is not following the orders of the central government according to the constitution. During that time, this Article 356 will be imposed. That is another thing. But there are various, but there are certain times when this president rule should not be imposed. So we will see those things as well. When a ministry resigns or is dismissed on losing majority support, immediately Article 356 should not be imposed. The governor should ask for formation of government for other parties as well. When no party claims the majority and no party forms the government, only then 356 has to be imposed. And when the next the next thing, if you see, when the governor makes his own assessment of the support of a ministry in assembly and recommends imposition of president rule without allowing ministry to prove majority. Okay, so that means the government has not consulted other parties, and the governor has not given them the opportunity to prove the majority on the floor of the house. When the ruling party enjoys majority support in assembly but has suffered a massive defeat in general elections or to Lok Sabha, like even during that time, the governor rule should not be imposed just because the government changed. Okay, that is also another thing. So next question, if you see the 78th question, it is with regarding to the Constitutional Amendment Acts. The Constitutional Amendment Act generally is dealt by Article 368, as you all know. So if you see 42nd important Constitutional Amendment Acts, and one of them is 42nd Constitutional Amendment Act. Under this 42nd Constitutional Amendment Act only, even the fundamental duties came into place. So Article 74 clause 1 says that there shall be Council of Ministers with Prime Minister at the head to aid and advise the President, who shall, in accordance with such aid, this statement was added by the 42nd Constitutional Amendment Act. Next thing is with regarding to the reduction of voting age. Earlier the minimum age for voting is 21 years. So this was reduced to 18 under the 61st Amendment Act, under the 61st Constitutional Amendment Act. Next, the state can make special provisions for advancement of social and educational backward classes and also SC and STs. This was added by the first Constitutional Amendment Act. So this is nothing but, or you can say under this article only we are having reservations currently. So this is the 78th question. Now let's move on to the 79th question, which talks about the ultra long period magnetar, the ULPs. See, magnetars are the type of isolated neutron stars that possess most intense magnetic fields. So they are type of neutron stars with intense magnetic field. The ultra long period magnetar ULPs, they are a type of slow spinning neutron stars, you can say. They are slow spinning neutron stars, and they experience violent eruption of intense bursts in the form of transient X-ray pulses, which are several higher orders of the sun. So this is about the ultra long period magnetar ULP. Here you might get it out. What is a neutron star? Neutron star is nothing but the collapsed core of a massive star. That is called as neutron star. Okay. Next question is on DPSPs, directive principles of state policy. The DPSPs, if you see, they are the instructions for the government about how they have to govern the country. The DPSP confers no legal rights and create no legal remedies. That means if the government does not implement any DPSP, you cannot approach the court. That is the primary thing. The DPSPs, they are just like an instrument of instructions to the government. They serve as a beacon of light for the government and the courts, but they don't have any legal obligation. They don't provide any legal obligation for the government. They amplify the preamble. The objectives of the preamble is mostly ensured through these DPSPs. Why I say mostly? Because there is this political justice. The political justice generally is ensured through fundamental rights, but other justice, the social justice, economic justice, this will be ensured through the DPSP. That is another thing. And they are supplementary to the fundamental rights, because fundamental rights, as I said, ensures this political justice. It will give the people the power, the freedom, equality and everything, but it is the DPSP which will ensure welfare. As it is said in the preamble that we are a country which has socialist goals, socialistic objectives. These socialistic objectives is also ensured through the DPSPs. So tomorrow there might be a statement directly, the socialist objectives of the preamble is ensured through DPSP. It is a right statement. Okay. Right. So next one, it also enables the opposition to exercise influence and control over the operations of the government, and also they serve as a crucial test for performance of the government. This is another thing. Next, 81st question is on the Citizenship Act of 1955. So Citizenship Act, if you see, a person can gain Indian citizenship by birth, descent, naturalization, registration and incorporation of territory. These are the 5 ways by which a person can become an Indian citizen. Now what are the ways by which a person can lose his citizenship? There are three ways. The first is renunciation. That means a person willingly he chooses to leave Indian citizenship. Next, termination. Termination is when an Indian citizen acquires foreign citizenship, then he will automatically be terminated, or he will lose the Indian citizenship automatically. Next is by deprivation. By deprivation means the government taking away, that is government taking away, that is called as deprivation. So, when will the government take away? If the citizen has acquired citizenship by fraud, if the citizen has shown disloyalty to the constitution, if the citizen has unlawfully traded with enemy during war, if the citizen has within 5 years after registration or naturalization is imprisoned in any country, or if the citizen has been residing out of India for 7 years continuously. Under all these conditions, the citizenship of India can be taken away by the government of India. Next, 82nd question is on the Sikh thugs. So, Sikh thugs, why it was in news recently is because the Delhi Assembly passed this amendment bill to the Delhi Sikh Gurudwara Act of 1971, recognizing the Takht Damdama Sahib. So, now what is this Takht? So, Takht is nothing but, in simple words, it is that body, or it is that person who will issue hukums from time to time. That means they issue various rules and various orders for the Sikh community from time to time. There are 5 Takhts in total: the Akal Takht in Amritsar in Punjab, the Takht Keshgar, it is also in Punjab, the Takht Damdama Sahib, this is also in Punjab. These 3 are in Punjab, whereas the other 2 Takhts, Takht Patna Sahib in Bihar and Takht Hazur Sahib in Nanded, Maharashtra. So, these are the 5 Takhts. So, in Persia, Takht is nothing but the throne. Takht is nothing but the throne. Generally, the Takht is appointed by the Gurudwara Shiromani Prabandhak committees. Okay. So, these are the Takhts, and among all the Takhts, the Akal Takht is the most important Takht. Akal Takht is the most important Takht, and it is the oldest of all the Takhts. Right. Next question. The 83rd question is with regarding to the constitutional amendment. So, Article 368, as you all know, deals with the constitutional amendment. Right. It includes abolition, creation of legislative councils in the state, and citizenship, acquisition, termination, etc. So, and also the majority of the provisions in constitution need to be amended by the special majority of the parliament. So, under Article 368, if something has to be amended in the constitution, then this amendment or this resolution has to be passed by both the houses with more than 2/3 of majority of present and voting along with 50%. That means 50% strength has to be there, plus 2/3 present and voting has to vote for it in both the houses. Only then this resolution will be passed, and it will change the constitution. Okay. This is about Article 368, and under Article 368 the fundamental rights, DPSPs, okay, they can be amended. Next is Attorney General. Attorney General, if you see, he is the highest law officer of the country. He is appointed by the President. He will remain in power till the time he enjoys the confidence of the President. That means till when the government wants, a person can be Attorney General. Article 76 deals with Attorney General. Advocate General is the highest law officer of the state. But if you see the Solicitor General, he is not, the office of Solicitor General is not a constitutional office. Only Attorney General is a constitutional office. That is the thing. And the remuneration is not fixed, and also he can take up private practice on the permission of the government of India. He also is part of the parliament. He can speak in the parliament. He can take part in the proceedings. The only thing is that he cannot vote. Only voting is something which is not available to him. Next, question number 85. This is with regarding to the freedom of speech and expression. So, Article 19 talks about freedom. Article 19 talks about freedom, and if you see in Article 19, we have Article 19 clause 2. Article 19 clause 2, which provide reasonable restrictions on the freedoms. Reasonable restrictions on the freedom. Article 19(1)(a) talks about the freedom of speech and expression, which is available to all the citizens. Article 15, 16, 19, 29 and 30, they are available only to the Indian citizens. Remember this. Okay. Next, another important thing is the restrictions the restrictions for this freedom of speech and expression, if you see, because these all the rights, if you see in Indian Constitution, they are not absolute. There are certain reasonable restrictions. So here, what are the restrictions? Sovereignty and integrity, security of the state, friendly relation with foreign countries, the public order, decency, morality, or in relation to the contempt of the court, defamation, or incitement to an offence. These are the various exceptions. Okay. Next is the village panchayat. So, village panchayat, if you see, Gandhiji has always advocated for self-governance model through village panchayats. The 73rd Constitutional Amendment Act deal with the Panchayati Raj institutions. You have the PISA Act of 1996, which deals with the Panchayati Raj institutions of the scheduled areas, and the 74th Amendment Act deals with the urban local bodies. Next question, the 87th question is on Article 22. Article 22, if you see, this deals with the protection of persons who are arrested or detained. In detention there are two types, punitive and preventive. The punitive detention is detaining a person. Punitive detention is nothing but detaining a person after the commitment of crime, whereas preventive means the detention of a person before the commitment of crime. So, in the preventive detention of a person without trial and conviction by the court. So, this is basically to prevent that person from committing an offence. Article 22 has two parts. The first part deals with the case of ordinary law, and second deals with the preventive detention. And this preventive detention, if you see, under this a person can be detained only for 3 months. Beyond 3 months, if someone has to be detained, then a committee has to be formed with the judges and all, and only after the recommendation of the committee, the person can be detained for more than 3 months. And also, the grounds for the detention should be communicated to the person who is detained, and the detainee should be given an opportunity to represent him against the detention order. And also, another important thing is that a person has the right to be released after 24 hours unless magistrate authorizes further detention, only if he is arrested under ordinary law, and this law is not applicable to the preventive detention law. That means, a person who is arrested ordinarily for the commitment of any crime, he has to be produced before the magistrate within 24 hours. If the magistrate says the person has to be detained, then he will be detained, or else he will be released. This is not applicable to the preventive detention law. That is the thing. Next, President rule. President rule is nothing but Article 356. The President rule may be invoked by the President at any time by a proclamation. It does not require parliamentary approval. Next, 44th Amendment Act in 1978 provided that beyond 1 year if the President rule has to be imposed, then the Election Commission of India has to give a certificate that conducting elections in that area is not possible. Conducting elections in that area is not possible. Only because of that, the President rule is extended. The Election Commission has to certify that. That is there. Okay. Next question, the 89th question. Just a second here. So, 89th question is dealing with the Indian Independence Act. The Indian Independence Act, if you see, by this act, the Constituent Assembly was made a fully sovereign body. The Constituent Assembly. We have discussed this already in yesterday's class. Constituent Assembly, the composition and all. Right. So, Indian Independence Act of 1947. This is also very important. The representative of princely states are also part of this Constituent Assembly. They elected members. So, who are the elected members? The elected members of the provincial legislative assemblies. They are also part of the Constituent Assembly. So, election does not mean in the Constituent Assembly direct election. The indirect elections took place. The indirect election took place. Next, provincial subjects. So, question on provincial subjects. So, here it says that under the 1919 Montagu-Chelmsford reforms. So, here there are the provincial subjects are divided into two types. First is transferred, and next one is the reserved. Okay, transferred and the reserved. So, transfer subjects, they are administered by the governor along with the help of ministers, while reserved list was to be administered by the governor and his executive council. That means transferred means they are transferred to the governor. Reserved means the executive council will be dealing with the reserved ones. Okay. So, they are reserved for the executive council. In fact, in simple words, the transferred subjects, okay, they are dealt by the government in place, whereas the reserved subjects, they are dealt by the governor directly. That is a simple thing. Transferred by the government, reserved by the governor. So this system is called the diarchy. Diarchy. It replaced the Indian Legislative Council with bicameral legislature consisting of two houses. Elections to both were by direct elections. It separated for the first time provincial budgets for the central government and authorized provincial legislatures to enact their budgets. And separate electorate for Muslims was introduced by the Act of 1909 itself. This provision was extended to Sikhs, Indian Christians, Anglo-Indians, Europeans, etc. So 1909 provided for separate electorate to the Muslims. Next, 91st question is on the Statue of Equality. Statue of Equality is the world's second tallest statue in a sitting position, and this is of Acharya Ramanujacharya. So Acharya Ramanuja, you might have studied in your history in the Bhakti movement. He is a Vishisht Advaitavad, so he is the chief proponent of this Vishisht Advaitavad. Advaitavad is propagated by Adi Shankaracharya, whereas Vishisht Advaitavad is by Acharya Ramanuja. Acharya Ramanuja. So this statue is there in Telangana near to Hyderabad. Okay, and it is made up of Panchaloha. Panchaloha means 5 metals: gold, copper, silver, brass and zinc. So the inner sanctum deity of Sri Acharya Ramanujacharya is built of 120 kg of gold. It commemorates 120 years of saints spent on the earth. He was also called Ilaya Perumal. He was one of the most influential Bhakti movement. He was an influential person in the Bhakti movement, in fact, and he also wrote influential texts like the Bhashya on Brahma Sutras and Bhagavad Gita in Sanskrit. So this is about the Statue of Equality. And what is Vishisht Advaitavad? So Vishisht Advaitavad is nothing but it is a non-dualistic school of Vedantic philosophy. It is non-dualism of a qualified whole, which is Brahm alone exists, and we humans are nothing but we are part of Brahm, we are part of God, we originate from the God, and finally after death we merge into God. This is what is said by the Vishisht Advaitavad school. Next one, the dual citizenship. India, as you all know, does not allow dual citizenship. This dual citizenship can be found in USA. They have the state as well as center citizenship. In India, we have only one citizenship, that is by the government of India. Though Indian constitution is federal and encourages dual polity, but it provides only single citizenship, unlike USA. And even in Switzerland, it also has a dual citizenship. Next one, 93rd question. This is on the basic structure. We have already discussed a lot on the basic structure, so just refer the previous videos for this discussion on basic structure. Next, important laws. See, just a small thing before I move forward. The main intention behind this is that you will be able to retain things. See, here we are discussing important laws. This question basically is on important laws. Important laws means here this question is directly on the Article 20. So you have to now think that, okay, what consists of Article 20? It consists of 3 things: the protection against self-incrimination, no double jeopardy, no retrospective criminal legislation. You have to, all these 3 has to come in your mind. If it doesn't come in your mind, just listen here and try to retain in your mind. That is what you have to do. Okay. So this is about, and now coming back to this question, 94th one. So it is about important laws. Here the question is on Article 20. So protection against self-incrimination, it does not extend to compulsory protection of material objects, compulsion to give thumb impression, signature, blood specimens, and a compulsory exhibition of body. Next, protection against double jeopardy. That means a person cannot be produced before the court twice for the same crime. He cannot be punished twice for the same crime. That is the thing. No double jeopardy. And the third is, the last one under this article is retrospective criminal legislation. The retrospective criminal legislation is, see, generally laws will be passed by the parliament. There are various tax laws that will be passed and it will be imposed from a previous date. For example, if a law is passed in 2022 December, they can pass a tax law stating that this law will be applicable from 2020 January. Something like this, the law can be passed. But this law or this retrospective application of law is not possible for criminal laws. It is only for civil laws. That is the thing. Next, 95th question is a constitutionalism. So constitutionalism, it means that the power given to the government are not unlimited and they are limited. We have the basic structure which limits the powers of the parliament. So this basic structure, though is not provided by the constitution, it is provided by the Supreme Court. So constitutionalism is nothing but the limitation on powers of the government. the fundamental rights is one thing which limits the powers of the government. But on the other hand, we have DPSP. DPSP does not limit the government, rather it empowers the government. And also the fundamental duties. They are constraints on the part of citizens and not on the government. So, constitutionalism in itself is nothing but adhering to the constitution. Okay, that is the thing. Next, national emergency. So, Article 358 and 359, effect of emergency on fundamental rights. Article 358, as we discussed already, deals with fundamental rights guaranteed under Article 19, whereas Article 359 deals with suspension of other fundamental rights except Article 20 and 21. Article 359 deals with suspension of other fundamental rights except Article 20 and 21. In simple words, I will tell you, in simple words, there are two articles, Article 358 and 359. What is their duty? Just a second. Yeah. What is the duty? Suspension of fundamental rights during national emergency. Under Article 358, when there is national emergency, the fundamental rights under Article 19 will be suspended. The fundamental rights under Article 19 will be suspended. That means the freedom will be suspended. But here the thing is, under 44th Amendment Act, what was brought in is only during external aggression. This Article 358, only during external aggression, this Article 358 will come into force. Okay, this is the thing. You have Article 359. Article 359 deals with suspension of other fundamental rights. So, literally suspension means not suspending, rather than the power, or Article 32 is suspended. That means for the violation, a person cannot approach the court, but the rights will be in place. Rights will be in place. This is the thing. So, but another important thing is under Article 359, even under the internal conflicts or armed rebellion, internal armed rebellion, this Article 359 can be imposed, unlike the Article 358. That is the basic difference. Because under Article 352, national emergency can be imposed if there is external aggression, that means by any outside country, or even by the armed aggression of internal people. So, during these two times, the emergency can be imposed. But when the external emergency is there, when the outside country is attacking us, then under 358, which article is suspended? Article 19. Okay, that is the thing in simple words. Now, I think now it is clear about Article 358 and 359. Now, let us move on to the next question, 97th question. This 97th question deals with the linguistic minorities. So, originally Constitution did not make any special provision for the linguistic minorities, but later State Reorganization Commission of 1953-55 made a recommendation in this regard, and accordingly the 7th Constitutional Amendment Act of 1956 was inserted, and Article 350B in the Part 7 of Constitution it came into force, and the article contains provisions like special officer for linguistic minorities will be appointed by the President, and it is a constitution, it will be under Constitution. This is the thing. Next, implementation of DPSPs. So, as you know, the DPSP's implementation cannot be questioned in any court like that of the fundamental rights, because the directive principles of state policy are nothing but the instructions of to the government. Article 41, it talks about securing right to work, education, public assistance with respect to employment, old age, sickness and disablement. Article 50 calls for separation of judiciary and executive. Also in the mains also we have seen Article 50, it is used for the breach of separation of powers and over there. And Article 48 under DPSP calls for modernization of agriculture and animal husbandry. So, in GS3, when you are writing an answer on either animal husbandry or agriculture, you can use this Article 48 directly. And Article 41 calls for providing right to work, while Article 43 calls for provision of living wages to all the workers. This is the thing about the DPSPs and all. Next, specialized wings of Niti Aayog, 99th question. There are 3 specialized wings: research wing, which is a dedicated think tank. Next, consultancy wing, which provides for marketplace of vetted panel of experts and funding for central and state governments to tap into matching their requirements with the solutions. Next is Team India wing. Team India wing comprises of representatives from every state and the ministers, and it serve as a permanent platform for the national collaboration of the representatives. So that is the thing about the specialized wings of Niti Aayog. Next question, last question, 100th question is on equalities. Equality of status, equality of opportunity, equality before law, and equality of outcome. So Article 14 talks about the right to equality. In simple words, we have broadly Article 14, 15, 16, 17 and 18 talks about equality. So equality of status is ensured through Article 17 because it abolishes untouchability and all. Equality of opportunity is ensured through Article 15 and 16. Equality before law is ensured through Article 14, and equality of outcomes can also be ensured if people have same material wealth and income, or in which general economic conditions of their lives are alike. But Constitution does not provide anything for the equality of outcomes, because outcome is based on lot of conditions which are very subjective, right? So these are the 100 questions of test 1. Okay, hope you have revised all of these questions and they are helpful. Do leave in the comment box if you have any questions or queries, and do let us know if you want anything extra. Okay, so that's it guys for this lecture. I'll see you again in the next one. Till then, keep studying and stay tuned. Jai Hind.